first matter to come before us this morning is State of Ohio versus Theodore Higdon. The appellant has waived oral argument. You have 15 minutes to do it as you choose. We have read the briefs and we're ready to see when you are.
Thank you. Good morning, Your Honors. My name is Matthew Kern on behalf of Dean Holman, Medina County Prosecuting Attorney. I represent the state of Ohio in this matter. I'd like to focus the court's attention on, I'll take the order of the assignments of error in order, if that's easiest for everyone. First, the jury selection issue. Mr. Higdon alleges a fair cross-section violation. The Supreme Court in State v. Fulton in '91 identified the three-prong test from Durham v. Missouri as the appropriate analysis here. And those three prongs are: 1, that the group must be distinctive; 2, that representation of the group is not fair or reasonable; and 3, there is an underrepresentation because of systemic exclusion from the veneer. Now, this case, even if you decide that the alleged group which is underrepresented on Mr. Higdon's jury was men, which I must admit was the first time seeing that, Mr. Higdon still fails the second and third prong of the Durham test, because there is no evidence in this case that there was a significant underrepresentation. In fact, there's no evidence in the record the number of men versus women in Medina County. There's no evidence in this record of the total number of men called as part of the veneer, and there's no evidence of, actually the other point I'll make is that Mr. Higdon failed to exhaust all of his peremptory challenges, and the record notes that there was an additional man who could have been included in the final composition of 12 had Mr. Higdon used his last 2 peremptory challenges. He failed to do so, and under State v. Trimble, that means that this claim is forfeited, that he actually functionally waived the claim by failing to exhaust his peremptory challenges. Moreover, counsel acknowledged at page 328 of this transcript that the way that jurors are summoned for jury duty is a random draw process. As State v. Johnson, 1972 notes, jury selection based on voter registration does not systemically exclude make, and there's no evidence of underrepresentation in this record, which is also fatal to his claim. Now, most importantly, in State v. McNeil, the Ohio Supreme Court noted that underrepresentation on a single veneer does not make a systemic exclusion. Systemic exclusions must be a calculated policy, a repeated practice that results in the constant, consistent exclusion or underrepresentation of specific identifiable groups. In this case, the only evidence that Mr. Higdon even attempts to point to is his own veneer. The fact that a particular veneer happened to contain less men than he otherwise would like does not a fair cross-section violation make. In this case, the only evidence is the number of men called as part of the veneer and who ultimately ended up on the final pettit jury. There is no evidence in this record, contrary to this court's particular requirements of the defendant's burden to present evidence of the number of men, the percentage population, additional facts from which the court could conclude that there was an underrepresentation. State v. Hairston, the Ohio Supreme Court's decision in State v. Moore. The absence of evidence on this point is completely fatal to the claim. And unless the court has any further questions on this area, I would like to move on to the second assignment of error. This assignment of error challenges the manifest weight of the evidence, and I think it's important to note that unlike yourselves who are reviewing a cold paper record, the jury in this case had an opportunity to see the witnesses as they testified, to hear the compelling testimony of the victim who described in some particular detail the events as they transpired. They had an opportunity to hear from the investigating officers, to hear from licensed therapists who examined and helped counsel the victim in the aftermath. They heard that the victim's behavior was consistent with one who has been the victim of a sexual offense. That there were details that emerged that is consistent with the behavior of victims of these kinds of offenses. details do emerge as stigma is reduced and it becomes more acceptable to share information. That it's not so much a personal, this happened to me, is now a healing process. That is consistent with other cases. The jury had an opportunity to hear, to observe witnesses' demeanor, tone, some things which do not necessarily come across in a paper record. Their determination of the witness's credibility is entitled to a significant degree of deference. There's also the bit of DNA evidence in this case from the amylase found on the victim's underwear that was collected by police, which was examined and found to contain a mixture of the victim's and Mr. Higdon's DNA to a degree of frequency of occurrence of 1 in 2.974 billion unrelated individuals. That is more people than are currently in the United States, which has a population of only 300 million people. Finally, this was a jury trial, so under the Ohio Constitution, Article 4, you must be unanimous, 3-0, that the evidence in the defendant's favor weighs heavily against conviction, such that this was an extraordinary case resulting in a manifest miscarriage of justice. I do not believe that you can make such a determination in this case based off all the evidence presented at trial against the relative paucity of evidence presented in the defendant's favor. I'll move on to the third assignment of error very briefly. I understand the court has oftentimes applied a de novo standard to hearsay evidence, but the Ohio Supreme Court has held that when reviewing the admission of evidence in a criminal case, the standard of review is abuse of discretion. Here, there is no evidence that the trial court abused its discretion. On redirect examination, following defense counsel's use of the particular document in cross-examination, the state asked for a complete or a more complete, because certain information was withheld for prejudicial concern, for 403 purposes. The state asked for a complete understanding of the total context of the letter, to put the material used in cross-examination in context for the jury. When asked, defense counsel, page 560 to 561, indicated that he was only using the letter for impeachment. He was not offering it for the truth of the matter asserted. To put the letter in context, then, is also not a substantive use of the letter. It is not offered for the truth of the matter. It's offered to rebut the implication or fabrication. It's offered to rebut the potentially impeaching effect. To do so does not make the letter substantive truth. Therefore, under 801C, because it's not offered for the truth of the matter, it is not hearsay. And because the defendant's assignment of error, as captioned, asserts that it was inadmissible as hearsay, the assignment of error therefore fails. I'll also note that under Evidence Rule 106, the assignment of error should fail because it was offered for completeness. It was not offered for substantive truth. It was offered to put the potentially impeaching nature of the paragraph that defense counsel had the witness read in context with the totality, excluding the 403 portion that was not read, in context. Now, if you do get to the merits, and if you do not wish to go further, I'll stop. But if you would like argument about the merits of double hearsay or invited error, I'd be happy to go on. But I'll note that because this was not offered for the substantive truth of the matter asserted, it's not hearsay under 801C. The assignment of error therefore fails. Unless the court has any particular questions about other aspects of the case or more particular questions about assignments of error, I gladly thank the court and will yield back the balance. Thank you very much.
Thank you. The court will take the matter under advisement, issue a written decision which will be mailed to both sides as well as posted on our website and the Ohio Supreme Court website.